It's Tuesday afternoon at 4 p.m. in Switzerland. It's Space Café WebTalk time. Our Space Café WebTalk, 33 minutes with Christopher Johnson, will begin soon. Thanks for joining us for this very informative and definitely inspiring event about lunar exploration. How big is the tent? As always, we appreciate your participation and your ongoing feedback. I'm Torsten Kriening, your host today and publisher of SpaceWatch.Global. We are a Europe-based online platform for information in and about space and new space activities in a geopolitical context. I think many of you already are already familiar with our website, our bi-weekly newsletters, daily newsletters, and the Space Café podcast. This morning, we released episode 8 of our podcast on all major podcast platforms, featuring Michelle Hanlon of For All Moonkind, if this is not a perfect timing for it. If you've missed any of our previous web talks, we have an archive available on our website in the event section and now on YouTube as well. We host our Space Café web talks on a weekly basis. This is already the 19th edition. I hope you mark Tuesdays at the same time in your calendars. Today, I'm very honored to be joined by a good friend, a very special guest, and somebody I admire for his outstanding work. Welcome, Chris Johnson. Welcome to the show.
Thank you for having me. Good to be here.
I hope it's okay to say that I'm a big fan of you. However, Chris is a space law advisor for the Secure World Foundation. Prior to joining Secure World Foundation, he worked as an attorney. Why is English such a difficult language?
Coming in. Yeah. Give it another shot.
No.
Attorney.
Attorney, thanks. In New York City, and entered the space field in 2010 as an intern at UNOSA in Vienna. He also served as an intern in the Office of International and Interagency Relations at the NASA headquarters in Washington, D.C. and in the International Law and EU Legal Affairs Division at the ESA headquarters in Paris. Why do I say that? Remark to all of you in the audience that are looking for a career advice. I hope you listen carefully. Interns is a way to go. However, Chris serves also as an adjunct professor of law at the Georgetown University Law Center in Washington, D.C. He is also adjunct faculty. It's better. At the International Space University in Strasbourg and legal advisor for the Moon Village Association and a core expert and rule drafter in the Milamos project. With that, I leave it to your outstanding career and not going into further detail. I'm very proud to welcome you, Chris, again in my show. Let's start here. I would like that you set the scene for us. Many in the audience are space lawyers like you, but many aren't. So can we briefly, or can you briefly recap the basics? Simply question, who owns the moon?
Who owns? So, I mean, I think that it's easy to state what the law is because it won't take much time to say what we know for certain. And what we know for certain is the Outer Space Treaty and the modesty and the limits of the Outer Space Treaty, whether it's Article 1 stating that exploration and use shall be the province of all humankind. So outer space is free for actors to explore, to access, to explore, and to use. And in fact, use and exploration is in the very title of the treaty. With permission from other states or from the United Nations. So there's that great freedom of access. And then, of course, balanced against that is Article 2 of the Outer Space Treaty, which serves as a limit on that freedom and which, well, we could take a look at it. And I sent you a copy of the text of Article 2. And we can look at that as some type of obligation or limit or caveat placed on the great freedom of Article 1. And it essentially speaks about national appropriation. And essentially, Article 2 is the only normative guidance that we have to answer that question, who owns the moon? And it's essentially no one owns the moon. But if you could please put up so here's the text of it. It's a short 17 words. Outer space and then the phrase including the moon and other celestial bodies, but we just say outer space. And here's the verb and the direct object of the sentence. Outer space is not subject to, and it is not subject to what? To national appropriation. And then a list of ways that it is not subject to national appropriation: by a claim of sovereignty, by means of use or occupation, or by any other means. That by any other means is meant to be broad and inclusive. So we know outer space is not subject to national appropriation. So some people, make this quite simple, and they say claims of sovereignty in space are illegal. So I would ask you, Torsten, or any of the listeners or watchers, if a state, let's give an example. Let's say a state comes out and makes a claim of sovereignty over the moon or a subset of the moon. Is that act of making a claim of sovereignty, is that act illegal, a violation, a non-observance of international law, the mere act of making a claim? Well, if it was, then this Article 2 would have said, claims of sovereignty are illegal, or states shall not make claims of sovereignty. But it doesn't. The subject of the sentence is outer space, and it's kind of giving a definition of what outer space is, saying outer space is not subject to national appropriation. So I would think that the act of making a claim of sovereignty, that's not the illegal part. It merely means that if you were to make some type of claim, it would not justify or legitimize or perfect your national appropriation. It has no legal effect, that claim of sovereignty. Additionally, the other listed methods, but use of outer space, occupation of outer space, they do not solidify or perfect or concretize or legitimize purported national appropriation. So it doesn't really give a character to those acts, merely to say it will not. Those acts do not give rise to a permissible, legitimate national appropriation, because outer space is not subject. It is not an area which is subject to national appropriation. So a claim of sovereignty or a use of space or occupation of outer space, guess what? That's not illegal per se. It merely has no legal effect in terms of its national appropriation. So you can use outer space. You can occupy outer space. You can occupy the moon. You can occupy celestial bodies. You can use those bodies. And it doesn't, and the effect of that is, it doesn't create a national appropriation. So let's marry that to the title of the treaty, Exploration and Use of Outer Space, exploration and use in the very title, and the great freedoms of Article 1. And I'm afraid that's all I can tell you. Who owns the moon? Well, no one owns the moon, but we have these great freedoms to access and use. And if you do perform those activities of exploration and use, they do not perfect or have a legal effect on a national appropriation, because national appropriation is something that cannot legitimately be done. So I think that's an answer which hopefully is sufficiently legalistic to annoy people, and also unsatisfactory to a wide variety of stakeholders, whether they're the international lawyers or commercial activities. I've given something that is I think my interpretation is justified by that text right there, and it doesn't go any further than that by saying, by drawing hairs between national appropriation and private appropriation. People can use the moon, but they cannot. There's no national appropriation of the moon, and under that we have this great freedom to then go and do all the things we want to actually do in space. And the effect of it is here on Earth, common law systems, civil law systems. Well, common law systems have fee simple, absolute. They have these concepts of how we can use property, and that how your property rights can exist in relation to a sovereign government. A fee simple absolute, or maybe a tenancy at will, or merely an easement. You have the right to cross over some property because there's a walkway over that property that you don't own, but you have that easement. You can go over it. But as we go into outer space, where there is no national sovereignty, where there is no national appropriation, we're going to have to come up with new concepts and new terms for what we can do in outer space and on the moon, knowing that there's no national appropriation. No one can own a plot of land, I think, but you have great freedoms, maybe that are a term of years to use those resources that you find there, so long as you do it in a way that is also in accordance with all existing international law, non-militarization of the moon, etc.
I think we will come to that a bit later. Okay, but thanks for setting the ground here, and in this level of uncertainty, or as you call it, this level of freedoms. 2 weeks back, when talking with Niklas Hetman, he pointed out that right now the UN COPUS is in a hibernate status due to the pandemic. The international space-related talks does not happen in Vienna right now, just on the conversational side. Taking the title of our talk, How Big is the Tent? Who shall be included in these talks right now?
Yeah, so this is really the conversation for this year and this generation in terms of lunar activity. And we put lunar exploration, so the exploration is not the only activity we want to do on the moon, and I didn't mean to slight those lunar developers, people who'd like to have a long-term presence on the moon, people who would like to, all the varieties of human activities that we would like to do on the moon. It's, lunar policy, how big is the tent? Lunar development, how big is the tent? And, traditionally, the tent is pretty slightly narrow, I would say, because it's nation states at the United Nations Committee on the Peaceful Uses of Outer Space, COPUS, that meets in Vienna, and it's 2 subcommittees, as Nicholas explained, and as Nicholas serves as the secretariat to COPUS. But it's nation states, and there is the pathway for non-nation states, for civil society, like my organization, Secure World. There is the pathway for commercial entities to have some type of say. But as I said, Article 1, exploration and use is free for everyone without, boiled in preconditions. You don't have to ask permission from other countries. So how big should that tent be? How big must that tent be? Certainly nation states play a role because they are the principal subjects of international law. But we want to have a tent which also has private industry, which also has civil society, which also has a scientific community, all essentially on equal footing. But the difficult thing is how to get all those views incorporated, and how to weigh. Should those views be weighted? If you have the people who are really keen to develop the moon, and they're putting all their time, all their money, their energy, the entire life is devoted to developing the moon, and this is what they're really focused on, and they're going to risk millions and billions of their own capital and put that on the line to develop the moon. Does their presence and their willingness to contribute, should it be weighed differently than folks who only have views on it, or who can't get there, or the moon is a integral part of their culture, or their heritage, or their religion, or their personal beliefs, or their community beliefs? The moon is equally important to them. And since the moon belongs to no one, how do we weigh that? I think, and how do you actually take into account all those views and come to some type of workable path forward? If you merely object to development, you talk to people who work in environmental law, people who work in environmentalism and conservationism, they often tell the same story, which is, you consult with all stakeholders, you listen to all views, and then the development happens anyway. You talk to the environmentalists, you talk to the indigenous communities, and the developers and commercial interests listen patiently, and then they go ahead with the development anyway. So that's not a really good way forward if development always wins, if commercialization always wins, and things which are irretrievable are lost. So I don't have an answer to this. I merely want to point out that there's this facet of the discussion is one of the topics for this year and this generation of how do we, do the things that people want to do on the moon, but also not make irreversible steps and ruin things that can never be undone. Fortunately, the astrobiological concerns are lessened on the moon than they are on Mars. So there's that facet of it, of how wide should that tent be. And then the other facet that I think I want to get to in the time that we have is Whether these things are done at COPUOS, whether they're done higher at the UN Security Council, UN General Assembly, whether they're done with a more disarmament or security aspects to them, so that would happen at the Conference on Disarmament. Maybe those folks should be involved. Maybe Geneva should be involved, or whether it should be done at the UN or elsewhere on the international level, as in through multilateral treaties. I could point to the Artemis Accords. So there's the international level, or whether they should happen on the national level through national space legislation, through national programs, and whoever sets the norms and the rules for lunar development. That's who is the first mover and sets those norms. So it can happen on the national level, or maybe it doesn't even happen on the national level. Maybe it's done on an industry level. Maybe industry comes up with the norms and the guidelines of how that industry is going to go about setting standards. So the mining industry sets their own standards without governmental or international involvement in how they're going to mine the moon. Those are all different pathways forward, and unsurprisingly, people come to this discussion with their conclusion already deeply held. So the international lawyers come to this discussion and say, oh, we need a new international treaty. I have the answer to that question. It's a new international treaty. And the commercial actors come to that discussion and say, oh, no, we don't need an international treaty. We just need freedom to commercial actors to innovate. None of these positions are unexpected.
Let's try to sort it out a bit, because what you have done right now is you put these quite complex picture here on the table, or you draw it. What in his complexity is definitely not easy to answer. I mean, earlier you said, I mean, we have the Outer Space Treaty, and nation states are responsible to anything what happens by their commercial entities or by their actors, which having a specific flag or in their company. So I mean, there's always this supervision and monitoring element, and I mean, due to the copious hibernate status, or on the international level, there's no direct ongoing discussion possible. In that situation, we have now the US, and you mentioned Artemis Accords, to coming up with an parallel development. That's how it looks like at the moment for the rest of the world. So you're inviting, you representing in this call the United States, and we the rest of the world.
Fair enough. Okay.
You're going out to all the agencies, all the actors, and say, "Hey, you're invited to join us here on the Artemis Accords." So, but what does it mean in terms of the international copious related consents, searching, or mechanisms?
Yeah, I mean, I really don't see the Artemis Accords as somehow parallel to the international coordination done through COPUOS or some type of different pathway for international space law. Artemis Accords will have international legal effect, but they're for a specific program. They're for Artemis projects, Artemis partners, Artemis missions. So it is merely, no more controversial than, say, what would be in the ISS agreement, or many of the many hundreds of agreements that are of an international character that NASA enters into and has in place at any given time. I think NASA has, over 800 currently in place international agreements with, space agencies around the world for how they're going to do this mission. So if you go, the Juno mission or New Horizons, if there's an international component to it, there's an international agreement. It's international space law. And those were uncontroversial because they're programmatic in nature. They're about the mission and operations in nature. And I think Artemis, will have a larger effect because it is for the moon and return to the moon. And it seems to be some type of successor to the ISS program. But, as you look across it, the drafts and what we've seen so far of the elements of Artemis, they're in accordance with international space law, or they are filled in space law. So, something about transparent that concepts, maybe Artemis fills those gaps and fills those silences, I think is how I would say it.
Okay. I think we are almost lost you here, but I hope internet connection comes back. Taking one from further step, talk as the calls are getting louder to get the indigenous or people on board into the dialogue or about their views. I mean, you said very clear, yeah, that's fine. We had them on board in our Earthbound or in development on Earth already, and then yeah, we talked to them and then have done the development anyhow. So is that the same what you expect on the moon, or are you saying, hey, it doesn't matter if they on board here? So how can we deal with that? How can we open this dialogue and make it inclusive, or is it no need for it?
No, you have to have it inclusive, and you have to do wide stakeholder engagement. Otherwise, whatever you do in the future will be resisted. So you have to listen to everyone, and not just one community or the most vocal community. You have to listen to all interested communities. Otherwise, 5 years down the road, 10 years down the road, those people who were not listened to before will have a grudge on whatever you do. So unfortunately, that's the difficult task of. It's going to be very difficult to engage with everyone, and there still will be people who resist just on principle, that they don't want to see any change. They don't want to see things happen on the moon, and maybe they're even jealous of the fact that other people can go to the moon and do things. But it's certainly important to at least try. And hold on, the other thing that I was going to talk about is, Copus is on a hiatus right now, or it's it was canceled for this year. Our listeners in Europe will have a better understanding of the concept of subsidiarity, because that's a principle built into EU law. And essentially, it means that decisions should be taken at the lowest necessary level. And I think that is one pathway forward to solving, these different levels: international, unilateral, national, contractual, operational. Decisions should be taken at the lowest necessary level. So if you need international coordination and agreement on one topic, say the definition of space resources, or the right to remove space debris, or the elements of radio frequency coordination on the moon, if that needs to be taken at the international level, then that's fine. But you don't need a new international treaty to come up with operational standards on how wide your tire track should be for your lunar rover. So these things will shake out, hopefully, according to common sense and what is achievable.
Okay.
How does that sound to you? Subsidiarity. You've heard of that, right?
Yep. Yeah. I see this point, no doubt. I have doubts that we can solve the current issues with that replacement, because we need this international dialogue. We need this agreement on the highest level, or it's my opinion, because at the moment we are still in a status that we have fundamental questions not answered, but we are racing to the moon. And I'm not saying racing country against country or companies against we are on this track to the moon, and it's like the wild, wild west. I mean, everybody is running, and somebody will make it sooner or later. I mean, I think iSpace just released their 2022 or launch date,
Yeah.
or with some luck they will land and softly, or whoever. Somebody will do that. It will take 2 years, maybe 3 years, and then we have facts. So, and that brings my question in about the power of the commercial operators. And I mean, talking about iSpace is not talking about our Blue Origin or SpaceX, which are joining the race and putting in their really billions in these developments. So how does that fit into this entire picture? And I hope we have not lost you. No, you're back. Good.
I think I heard you the full way through. Maybe the video buffers. I mean, so some people have said, well, those who go there first get to make the rules. and that's just a fact of history, that those who do the activity first get to make the rules. That may be a fact of history, but that is not a principle of international law. It is not those who do the activity first get to set the rules for that activity. So maybe it's a contest between those competing principles. Those who go there first get to set the rules versus no, it's an international discussion.
Mm.
And I think that there will be major actors who do set those basic norms, and maybe Artemis Accords is one of those instances of they're trying to say to the world, this is the elements that we're going to observe in Artemis programs. Here's the 10 principles of Artemis. And that, of course, will invite discussion and occasion discussion at COPUOS. And we'll see how it plays out. I don't think that one state is going to be dictated to by other states that are not its partners on what they want to do on the moon. So if a certain country doesn't like concepts that in Artemis, well, they just won't be part of the Artemis program. They won't be able to veto, say, what is in our national approaches. But the discussion we had at COPUOS, what needs to be decided at COPUOS, hung up on treaties. But the second half of your treaty booklet that you get from the UN has the non-binding principles, whether it's the principles declarations or just the documents from COPUOS that are negotiated and adopted by consensus, like the advanced concepts on launching states, advanced registration practices. So, if you want to do something quickly at COPUOS, it would likely be one of those principles documents that is negotiated, that is modest in nature, limited in scope, and very concisely constricted on a few particular topics, like launching state, like registration.
Yeah. Okay. I mean, we could continue this discussion of talking about the lunar resources and the value of global commons, but I don't want to go there right now. I would like to go more into the role of the military powers, which are a strong power when it comes to space, on the moon. How would you see that? And I don't want, I do reference to the Netflix series or Space Force when rovers drive over each other. So, but how can we prevent, how can we mitigate these kind of risks? And yes, I'm aware of the safety zone principle in there, but is that really applicable in your opinion?
Yeah, this is something that I actually am worried about, because I was on a webinar last week about lunar development, and someone said, well, one way you can really push lunar development is to have military spending on the moon. And maybe I don't know, maybe there are military rationales to put military assets and infrastructure on the moon. U.S. military, some other military's infrastructure. That's a great way to ramp up spending and have an anchor tenant developing things on the moon. I remind people again strongly to take a look at Article 4, Paragraph 2 of the Outer Space Treaty. It's 4 sentences. It essentially almost completely demilitarizes the moon. So the long story short is that Space Force is not allowed on the moon. They're not welcome on the moon. Any enforcement of safety zones, there shouldn't be enforcement of safety zones because maybe they're just operational in nature. If you come within this zone, this is how you should behave. Not keep out, they're not keep out zones, but if you come within this zone, this is how you should behave. So, it should not be, the limits of military activities on the moon are pretty narrow. So for peaceful purposes, are welcome moon, but not for installations. Okay. So just, I encourage everyone, please read again Paragraph 2 of Article 4 of the Outer Space Treaty.
And please remind the 4th of August today when Chris said there will be no military on the moon. I hope your words will stay there. Let's, as we are coming to an end, let's take 1 or 2 questions from the audience. And Charles Stotler came with one, should commercial actors have a stronger voice in the international forum or forums? And if so, how do we bring that about?
Well, as the entities that are going to put their resources and time and capital investment in the activities, they risk it. So it's necessary for them to have a voice. Also, they will be the closest to the actual operation of some of these things. So if you're going to put some type of, mine at the lunar South Pole, Shackleton Crater, Malapert Mountain, they're going to know exactly how that operation should be done. If you need a safety zone, what type of coordination you're going to need. So in terms of the actual operators, you need to listen to the actual operators on what they're going to come up with. So of course, you're going to need to listen to them. It'll be a different discussion with everyone wearing different hats and apply that principle of subsidiarity that I spoke about.
Great. I think many of these questions we will send you later on to answer them. Let's pick one here, one short one before running out of time. How do you see the use of nuclear in outer space, potentially then including the moon? I mean, there are programs, and we reported about some NASA development on that lately. So how do you see that?
Yeah, in terms of power sources, they may be necessary. If you need long-term stable power service of heat, they could use nuclear sources, and we have the nuclear power sources pearls that we can maybe improve, iterate. So yeah, so that's something that agrees with adheres to international law. It's something that should be looked at, especially if say solar arrays, you can't use solar power.
Absolutely. Okay. Thank you very much. Yep, go ahead. I think we
asteroid mining, the space law is very modest in nature. There are silences in how we really get to use asteroids. And with that, we have to develop law. So there's a lot of space law yet to be made. That's a simple conclusion.
Absolutely. Chris, thank you very much. I'm afraid we have to come to an end, or even so, I would like to continue this exciting talk with you on this topic, as you know. But be sure we'll follow up on space policy, space law topics, lunar topics in our future Space Café web talks and in our magazines. So our next upcoming web talks are on the 11th of August next week. I will discuss with Ken Hodgkins our future global space economy and Quo Vadis after his time in the government.
That's going to be a good one. Make sure everybody tune into that. That's the real expert on Copus right there.
Absolutely, yeah, and I think he has something to say about his active time. But the week after, not less interesting, I have Renato Kaprun, the head of the Swiss Space Office, as my guest to talk about space innovations made in Switzerland. And on the 25th of August, I will have the talk with Thomas Jatzombeck. The official title is the Federal Government Coordinator for German Aerospace Policy, the German Aerospace Coordinator. I'm very proud to have him in the show. And he will talk with me about space in general in Germany and in Europe, and especially as Germany performs the EU presidency right now. All events are online on Eventbrite. As always, we would like to hear your feedback, so please check in with us on Twitter, Facebook, or LinkedIn. Don't forget to sign up to our daily and our bi-weekly newsletters. Thank you all very much for your interest today, and thank you, Chris, particularly for this exciting talk and being my guest. And thanks again to the entire team behind the scenes for doing this great job week by week again. I hope you all will stay safe and stay healthy. Thank you for joining us, and I hope to see you next week. In the meantime, visit our website and follow us on social media. Thank you very much. Bye-bye. Chris, thank you.
Thank you.